Okay, we're back talking about interrogatories, which is the next discovery method, and probably the one that is the first one in the process. Not as often thought about as depositions because not as quite as exciting because it's written documents. Uh, but interrogatories are usually one of the first things that happen, and they're pretty simple. But interrogatories are just the written questions submitted by one party in a lawsuit to another party. Okay, I mentioned in the discovery or in the deposition video about this concept that I can ask of the other party anything that's discoverable. Rule 33 relates to interrogatories. The answers to the interrogatories must be by the party upon whom they are served. Okay, so if I'm the plaintiff and I serve them on the defendant has to answer them. The general rule is you have 30 days to respond. The federal rules require no more than, or allow no more than 25 interrogatories, including subparts. Depends on states, have different ones. What can you obtain? Basically, that same old discovery rule under Rule 26B, that it's any non-privileged relevant evidence, whether or not it's admissible in court later. Okay, so that's what are interrogatories. They're pretty broad. You can ask about anything. One of the things that happens is the electronic ESI information, electronic stored information, who pays to obtain information that comes from that. It's generally the person asking for it. But there are 7 factors out of the Zublocki case, which was one of the first cases really that dealt with this ESI and the fact that it's really expensive to draw these papers out from that are scanned and in databases that you can't access and all those things. I'm aware of a case in Wood County that I believe it cost somewhere like $50,000 just to retrieve documents. After you hire programmers, go out into some database storehouse, I think out in the Midwest somewhere, just some big warehouse, have a programmer go and try to retrieve all that data. You have to have a programmer because the program has to know how to go access the data, and you have to build a platform to do that, and then retrieve it, and then sort it, and then you even have to have somebody, usually at trial, that can help you like access it while you need it. But there are the 7 factors of the Zublocki case. Basically, it talks about like, well, could I actually? How significant are the questions? And do I have an ability to pay? Do I need to know what comes from that information? And do I have an ability to pay? Because it seems like justice would be denied if I can't afford to have you go bring that out of your database. A lot of times the general rule about interrogatories, production of documents, all those things is that whoever's storing it has the cost to go find it, except that usually the old cost was just copies. So if I ask it from you and you just needed to get me copies, I'd have to pay you for the copies. That's pretty reasonable. I mean, you just go like, oh, it's all the boxes here, and you go make copies of it. What does that cost? But now we're talking about the defendant chooses to store that information in some database that's hard to retrieve from. The expense escalates hugely, exponentially is more expensive. And now should I have to pay for all of that, or should I just pay for the copies? What do I have to pay for? And that's what Zublocki is about, like the ability to get the information. Again, one of the complicating factors of ESI. Typically, the questions that are asked are to identify people, to establish facts through the 5 W's: who, what, when, where, why, and how is the 1H. You identify the documents I need to ask you about, identify what you're contending, what is it that you're saying happened in the facts, and usually, is there anything that is relevant that I haven't asked about? There may be objections, so that you might need a motion to compel the other side to answer the questions. Sometimes they have objections. Most objections to questions in interrogatories are resolved through good faith effort between the parties and informally decided. The courts do not really like to be brought in on these motions to compel, especially because a lot of times they seem like kind of like personal squabbles, things like that. Okay, I do want to raise one point here, and I raised it in the deposition point, but a non-party does not have to answer interrogatories. You don't serve interrogatories on a non-party. there might be another method basically to do that, to have a non-party answer basically interrogatory type questions, right? Wonder what kind of method that might be that you could exercise on a non-party, because you have this special power in the system. The judicial system allows this special power that allows you to reach out to non-parties and get them to do certain things for your case. Okay. Going back to the answers to interrogatories, how do you do that? Normally you have to do it in 30 days. You have to do them in writing under oath, so you have an obligation to tell the truth. You may reference your business records and then include them. You must make a reasonable investigation and try to find the answer. You always have to supplement your answers to interrogatories. That's true in all discovery. You may make those obvious objections, privilege. You may, sometimes the judge has to make that decision in what they call an in-camera review. So the plaintiff asks you for certain information. The defendant says that's privilege. The plaintiff's like, how do I know it's privilege? Are you just saying that? An in-camera review is where then the judge gets to look at it only by the judge itself, and the judge will review it and determine whether or not a privilege applies. So that way the plaintiff doesn't, then there's that neutrality. The plaintiff doesn't get to see something that turns out to be privileged. The defendant still can make the valid objection, and everybody can be relatively happy about that. Some of the other objections are that they're irrelevant questions. They're not relevant evidence. You're not asking for relevant items. They're overbroad. You're asking for too much. I can't narrow it down. It's vague, so I'm trying to guess at the answer you're looking for or what information you're looking for. Sometimes people ask unintelligible questions that just do not make sense. You can object on that basis. And unduly burdensome means that it would be so hard for me to get that answer that it would be cost prohibitive. That also goes back to where the Zublocki case and the ESI information comes in. If it would be unduly burdensome, then how do I go about getting that information? Okay. It seems unfair that you can just ask and then I get stuck with it. Okay. So that's the answers to interrogatories is the last part there. So there's the points in interrogatories.